Hello, everyone. Hello, hello. Delia Pena here, immigration attorney with your immigration update. It's a good one. So, just to let you know, as a reminder, I am coming here live every Wednesday to give you the latest updates on two new laws that the Biden administration has announced. We are checking in weekly because the law has not been fully published yet. We don't know certain things about the law. So I'm giving you the daily updates as I see them. Every day I check the news, the government websites, everything that we need to check as defense attorneys to make sure that you know what you need to know to be able to get access to this type of new legal relief. It is amazing, it's life-changing, and it can completely change the immigration status of you or your family member. So there are two laws. The second law is not as popular for some reason, but it is related to DACA recipients. DACA recipients will be able to benefit. However, there are very few details as far as the White House goes regarding this law. So that one is about kids or people with university degrees. We don't know exactly what the details are, but the administration has said that they are providing some type of legal relief and expedited work permits and social securities for those with university degrees, including DACA recipients. So this is huge news in terms of DACA holders who have not been able to get long-term renewals. They mainly get 1 to 2 year renewals. They do still have access to applying for advanced parole so that they can leave the country and come back both legally and with permission of the US government. However, like I said, not enough details right now to really go into that. What I will be focusing on right now is undocumented people who are married to US citizens. So here's what we know. You must be legally married to a US citizen. That means going to a courthouse, getting that piece of paper, and verifying with someone who is authorized to marry you, usually a judge or someone, a religious ordained priest or rabbi, who are able to marry you legally. You get that documentation and you are legally married. There have been some questions coming into my office regarding people with civil unions and all other kinds of things that happen on a state-by-state basis, domestic partnerships, for example. The US government has been pretty explicit here that they're looking for people who are legally married as of June 17th, 2024, to a US citizen. Okay. Any questions about that? You must ask an attorney, an immigration attorney who defends people while they're processing their applications. Number two, you must have been in the United States 10 years or longer as of June 17th, 2024. That seems pretty clear. There have been some questions to my office regarding what if it's one day, what if it's 1 week? You know, that's the type of thing that we're looking for. The government has been clear, as far as I'm concerned, that 10 years is 10 years. What they have been very clear about, though, is that they're focusing on a group of people who have averaged 23 years or longer in the United States. That's a very long time to be in the United States. People tend to get married, they have children, they have, a set, they buy homes, cars, they do things for their families that a traditional parent, meaning someone who's actively involved in their family's lives, they have all of that. They do all of those things. but they must have been here at least 10 years. So most have been here 23 plus years, minimum 10 years. The next thing we know is that you entered the United States without an admission, meaning nobody approved that you could come in and cross the border, whichever border that may be, a water border, a land border, maybe an air border by flight, but those are few and far between, far less than the land border entries. And so you're looking for a type of admission or parole, perhaps into the United States. Typically, this law covers people who entered without documentation, and that is a very big deal. It's a big deal because traditionally what happens in a mixed marriage, mixed immigration status union, if one person is a US citizen, then and the other person is undocumented, traditionally what happens is that the undocumented person has to complete the family petition by returning to their home country. And once you return to their home country, then you have an interview with the consulate, you submit your documentations, whatever they need, medical records, medical exams, any prior criminal history or anything that's related to that application process. And then they approve. They make the decision there in your home country at the consulate, whether you're approved, denied. They might give you a penalty for having undocumented presence in the United States. They might do a whole number of things. Some people are brave enough to go back to their home country and finish that process. Others view it as a huge risk. And that's why you have people who have been here 10, 20 years at a time, because they fear so much to return to their home country that they refuse to take that risk. And so the administration has made it clear that there are about 500,000 people who qualify for this type of what they're calling parole. It's a parole in place process. And we do have other paroles in place that currently exist. For example, those granted to military officers who can then petition for their parents, for example, who also entered without documentation. It is a privilege. It is not a right. It is a privilege granted by the US government for people who, in the case of military officers, for people who have served the United States in a military capacity and want to preserve their family, right? They want to keep their family here, and because they've been here for so long, and that way keep them safe, right? So the theory or the underlying motivation for this type of law is to keep families together. Military parole in place includes the officer's parents. In this case, what we're talking about is marriage to a US citizen. So they're talking about that family, nuclear family unit. And so the administration has made it clear that they're prioritizing with this new application, with this new rule, that they're prioritizing family units. That's really important to remember. Okay, so the United States, this application is going to be eventually, when it comes out, when it's official and made, when it's published, the USCIS will be receiving these these documents. And they evaluate these applications based on a case-by-case basis. So every single person, every single family that submits a petition will be evaluated per that person, what that person has done individually, whether they have any prior criminal history, any other negative immigration history. and what else that they might have in their background that could raise a red flag or cause some concern to the USCIS official. So it's very difficult to say just because your neighbor's cousin won a certain type of petition that you will too. There are many, many, many details that go into the processing of an application. So when you arrive at an attorney's office who defends immigrants, you will get an analysis that talks about those details. How are you answering these questions? How can you prove those answers? What are the consequences of your past documented behavior, which could be a DUI, for example. It could also be a past deportation. How are those past actions going to affect you now? And as we review your case, we are anticipating what kinds of problems you're going to have as far as the government is concerned. What kind of questions are they going to ask? Are they going to ask more questions about ABC or XYZ, for example? And so that is the purpose of going to an attorney. In this case, with this marriage-based petition, what we're looking at are two things. We're looking at the parole in place, and USCIS has also made it clear that the ability to qualify for a green card, which comes much later, and that is where a huge benefit lies as well. Will this person qualify for the future green card? And what are the likely chances, if they have, several illegal entries, the chances are they're not going to qualify for legal permanent residency. So there's a two-step thing going on here. First, it's a parole in place, right? Where they're saying, okay, we're going to grant you this parole in spite of the way you entered without documents. And because you now have that parole, and this goes for the military parole in place as well, because this individual, formally undocumented, has that parole, now they can get work permits and social security numbers by applying for them. And that now legal entry, that parole in place, it's a type of legal entry in a sense. That's how you can think of it. That allows you to apply for a green card. And that is a completely separate process, completely separate analysis. What the types of evidence involved to petition for a family member for a green card, very, very different. But during the parole process, that's what's important. That's where we're already making that family petition assessment in our minds as immigration defense attorneys and as USCIS. So in addition to what we know about the rules, right? Being married to a US citizen, 10 years plus in this country, and not having a current legal status, there's also a very broad discretionary factor that is involved in all of these petitions. Any petition that you see with the United States government, well, almost all, and there's some details there, right? But there's a discretionary factor that is embedded in most, I'll say most, immigration applications. And the reason for that is because there might be some red flags that pop up where the officer is analyzing whether they will eventually be, this person might be a threat to the United States national security, or they might be a threat to public safety in the future. And so these are difficult obstacles to overcome. And these are sophisticated legal arguments that an attorney has to make to overcome them before the official reaches back out to you to address them, right? So as we're anticipating, we're providing documentation saying, okay, we see this problem coming up. Let's address it now. Let's address it during the beginning stages of the application. instead of waiting for the officials to come back with more evidence, requesting more evidence, for example. All right, so that's the latest so far. What I want to talk about now are the extra things that we have discovered since the last time that I posted a video. So what we know is that everybody who applies for an immigration benefit will get a background check. Every single person who attempts to enter without documentation, every single person who enters with CBP1 and they have an appointment, special parole, at the airport, by sea, however you try to come in, a background check is done. Fingerprints are taken, what the government calls biometrics are taken, which is, it can include a picture of your face, right? It can include your signature, if you write your signature on a piece of paper. And so these are important things that the government uses to document this individual standing in front of them. If you pose a threat to national security after they do the background check and they realize this person is a threat to national security, they are going to either continue an investigation or they're going to remove you from the country, i.e., they're going to deport you. And when they remove you that way, they have they lay out the justification for that. Okay, so if you're a threat to national security, you likely won't qualify for parole in place. If there is a suspicion that you are a threat to national security, you won't more than likely qualify for parole in place. Or those obstacles will become huge in terms of overcoming that suspicion that you are a threat to national security. Remember, USCIS, the umbrella organization or the umbrella agency is the Department of Homeland Security, DHS. Department of Homeland Security for immigration purposes includes USCIS, it includes ICE, and Border Patrol. If, you know, in terms of the 500,000 that the US is focusing on as people likely to qualify, I'm going to make an educated guess that there is a small percentage of those that are actual threats to US national security. What is more likely are those who are threats to public safety, threats to your local community, because of, for example, driving while intoxicated, or driving under the influence. This is a big deal because the government views that as a threat to your local community, to the public safety, right? And so when you're a threat to the public safety, even though you don't think you have a drinking problem or a drug problem, or you're taking legal drugs, they might be prescribed drugs, but they change your ability to make decisions, to control your body, or to think clearly, right? And then you hop into a car and you try to drive this 1,000-ton vehicle, right? It is a big deal to protecting the public's safety. And so if you have these types of this type of history in your background, you need to be very careful and think twice about filing this form. And the reason for that is because USCIS operates under the Department of Homeland Security, you are looking at you're facing their ability to refer you to ICE, or their ability to find a way to begin an investigation or continue an investigation, or something that will flag you not only in the system, but initiate some type of deportation or some type of flag in the system saying, hey, this person is a threat. We need to take care of them immediately. Okay. Um, it's a very big deal. And it's a big deal because sometimes people don't view, or they'll view, well, here's what I'll say. In the criminal justice system, misdemeanors, maybe your first DUI might be viewed in a sense that it's not that big of a deal. And you might try to carry over that idea into the immigration context. And there's a big problem with that because the criminal system or the criminal defense system has a high standard of proof. They have a high standard of that's required to be able to take away a person's rights if you're a U.S. citizen, for example, and holding people in jail unjustly, right? That's a restraint on your liberty, right? We have the right to be free, to live free in this country. For an undocumented person, there's a lot going on there regarding. Were you in the passenger seat? Were you in the back seat? Were you drinking? And the driver had an open container, and now you get hit with something as well. Many issues come up on the criminal defense side. The problem with comparing and trying to bring that over into the immigration defense side is that immigration has a much lower standard, meaning they will tolerate certain behavior far less than in the criminal justice system, right? The proof is higher in the criminal justice system, and so we have to, what we're doing is placing the burden on the government in a different way, the burden to prove that this case is true. And so if you're not represented appropriately, or if you are represented and your attorney was able to get your case dismissed on the criminal defense side, you need to think twice about that on the immigration side, even including with these petitions. And the reason for that is because this is the homeland security, right? We're looking at this from a much bigger picture. Are you a threat to homeland security? Have you had 2, 3, 4 DUIs? Do you get drunk and start fighting with people in public spaces? Do you have a whole bunch of domestic violence charges against you from different people filing against you? These are very serious things that might not seem serious in this criminal defense context, but are extremely serious to your presence in the United States as an undocumented immigrant. All right, so let me just check out my notes here. I do have one question that has been coming up in my office in the past week, and that is regarding previous deportations. What happens with this new marriage petition and you have a prior deportation? The most important thing to think about is, and this is the tendency for the government to view it in this way, right? Sometimes it matters how old the deportation was. Sometimes it doesn't. If it was one time and one time only, right, what they're looking for in this context, in the most ideal sense, is a person who entered one time without documentation. Many arrived as children, right? Many people who are now married to US citizens arrived as children with their family, and they didn't have much choice in the matter, much say. They couldn't, process what was going on, let alone make a decision saying, I don't want to do this, or let's do it. And so this new rule is specifically geared towards that individual. If you have a deportation, let's start from the beginning. If you have an undocumented entry, and at some point you were deported back to your country, and then you came back, that's 2 undocumented entries. Let's say you're deported again, You're sent back to your home country and you come right back. That's 3 undocumented entries with 2 deportations. And as your history grows, the more deportations that you have, the less likely that the government is going to see that in a positive way. The reason for all of this is to ensure that the person that's getting this green card under this new law is a person who follows the rules, right? Is a person who ultimately has followed the rules in all these other contexts, but for that one undocumented entry. And that is where a lot of people are going to have a problem, because so many people have the returns, the undocumented returns. So now you have 2 undocumented entries. Even with 2, talk to an attorney. You might not think it's a big deal. There's a whole generation of people who used to come and go because the border was not as protected as it is now. And they did not view crossing the border as an illegal entry. Maybe they knew it, but it wasn't a big deal 30 years ago, 40 years ago. Today, we need to look at this new law as it stands today. And today, it is a very big deal. It's a huge deal to have that, because now you're also a lawbreaker. And if you did it as an adult, those deportations and then illegal re-entries, now you're an adult who breaks the law. You're no longer a minor child who broke the law back in the day, right? So if you have that, you must consult with an attorney so that they can analyze what happened, how did it happen, when did it happen. But the government has started to say no deportations or no previous deportations. It's a big deal. So talk to an attorney so that they can tell you what's going on in your case and what are the chances. What kind of obstacles are you going to find in your case that the government is sure to bring up? Because they're not going to miss something like that. They have access to all of your documentation. Even if you think, well, I entered without papers, how are they going to know? There's ways to find out. Okay, so that's pretty much the end of that. Please keep calling my office. Keep answering. I will keep answering questions. I will come back here on Wednesdays. I was supposed to record live this morning at 10 a.m. But something happened with my volume. So here I am now, as far as producing, telling you about the latest updates. But the advertisements that go out will say Wednesdays at 10 a.m. I'm going to do that on a weekly basis just to update you, because what we don't know are how much is this going to cost? Can we paper file this or do it online? Does the application exist? The application right now does not exist. And if you try to file it based on a different type of parole in place, they're going to reject it, just flat out reject it. So don't do it. Just don't try it. Don't waste your time. Don't waste your money. Wait for the government to make that announcement. They will probably add other details to the law. They will publish more details on the USCIS.gov website. But like I said, don't waste this opportunity on if and maybe this person can help me fill out a form. This is not filling out a form. The purpose of these videos is to show you exactly how much thought and analysis and legal background goes into filing these applications. It is a very big deal. And if the government believes that you're lying or hiding information, or you omitted something that you think should not have been omitted, they will call you out on it. All right, so Wednesdays, 10 a.m. I'm aiming for mid-July. I'm hoping we will know much, much more by mid-July. So I have a big live scheduled for July 19th. And there we can answer any questions. But so far it's been working out pretty well. People are calling my office, people are asking questions, setting up consultations, getting their cases analyzed in a way that includes not just this law, but the potential for all legal relief that they might qualify for. So that's an even better assessment than just, do I qualify for this specific law? We're looking at the whole 360 spectrum of how you entered, what kind of legal relief is available to you now, does certain situations happen to you or not? That is all included in our consultations. So for those of you on Insta, hello everyone, thank you so much for showing up. You can call 956-831-1424. That is my office number. The initial intake is free. We will talk to you about what you might, we'll ask you a bunch of questions. We'll take some data. We'll ask you if you might be able to qualify for this or that. And then the second consultation is where we can actually give you some more concrete answers. For those of you on Facebook, LinkedIn, and all the other social media, you can see a QR code. So click on this QR code here. Basically, you're taking a picture of that QR code and you'll have access to the office calendar. That calendar will show you available times and you can schedule that appointment at your convenience when you have time and when you have availability. And that way you're already on all of our calendars and we're able to give you a call at that time. Lunch times are very popular. Maybe after 3 p.m. tend to be very popular with my potential clients, people who are calling in. So give us a call, let us know. I'll give you that number again. It's 956-831-1424. I am based in Texas. But immigration law is national law. So we're able to talk to people from all over the country to give them immigration advice. If you have a state question or you have some kind of state criminal history, that you will have to reach out to a specific type of state attorney for those reasons. But we can handle your immigration applications here in our office across the country. Thank you so much for being here. Wednesdays at 10 a.m. Central Time. So it would be 11 a.m. if you're on the East Coast. It will be 9 a.m. Mountain Time and 8 a.m. Pacific Time. Thank you so much. Belia Peña here, immigration attorney with your immigration update. I appreciate your time.